You have a buddy who served with you. They saw what happened. They know what you deal with every single day. So they write a letter for your VA claim, hand it in, and the VA gives it almost no weight. Why?
Think of it like handing a judge a sticky note instead of a sworn affidavit. The information might be accurate, but the format tells the reader you did not take it seriously. A one-paragraph buddy letter that says he is a great guy and he deserves his benefits is a sticky note. The VA needs an affidavit.
And I want to say this up front. Writing about what happened to you, or asking someone else to write about what they saw, is genuinely hard. A lot of veterans skip this step entirely.
The legal framework for this goes back decades. Lay evidence has been part of the VA adjudication process since Congress passed 38 U.S.C. Section 1154. The VA is required by law to consider it. The question is how much weight they give it, and that is where most veterans lose.
This is VA Benefits 1.31. Today we are covering buddy letters, personal statements, and PTSD stressor statements. 3 different documents, 3 different forms, and 3 different jobs. Stick with me through Scene 5, because the PTSD rules have special provisions most veterans have never heard of. Here is who is with me today.
Michael here. This is the kind of topic I could talk about for hours.
Hi, I'm Bella. I went down a rabbit hole last night and I have thoughts.
Hello, I'm Lewis. There is more going on here than most people realize.
Good to have everyone. Here we go.
The reason lay evidence matters in VA claims traces back to a fundamental problem. Military service records are often incomplete. Injuries go unreported, and sick call visits are not documented.
Under 38 CFR, Section 3.150(9), competent lay evidence is defined as evidence that does not require specialized education, training, or experience.
Think of a courtroom, Bella. An eyewitness does not need a forensics degree to testify that they saw someone get hit by a car. They describe what they observed. That is exactly what lay evidence does in a VA claim.
And here is the part that gives a lot of veterans hope. The 2007 Jandrow v. Nicholson decision established that lay evidence can be competent to identify certain medical conditions. A broken bone, a skin rash, difficulty walking. You do not need a doctor to tell the VA, your buddy cannot climb stairs anymore.
But there is a critical boundary. Lay witnesses are competent to describe symptoms. They are not competent to diagnose. You can write that your friend has constant ringing in his ears. You cannot write that your friend has tinnitus caused by blast exposure. That is a medical conclusion.
And that distinction is where buddy letters and medical nexus letters have completely different jobs. The buddy letter describes what happened and what it looks like now. The nexus letter from a doctor connects the dots medically.
Let me give you the picture of what a strong buddy letter looks like. A buddy letter is a witness statement. You are telling the VA what you personally observed when you observed it, and how it compares to what you see now.
The official form is VA Form 20-1-10210, the lay or witness statement. Anyone can write one. Fellow service members, family, coworkers, friends, neighbors.
Historically, the most effective buddy letters come from people who knew the veteran both before and after the event or deployment. That before and after perspective is what gives the letter weight.
If you are the person writing the letter, here is what the VA needs from you. Start with your relationship to the veteran and how long you have known them. Then describe specific events with dates and locations.
The key phrase is specific and observable. I noticed he started limping after the patrol on March 15th is strong. He has a bad knee is weak.
I watched her wake up screaming 3 times a week for the past 2 years is strong. She has trouble sleeping is weak. See the difference, Lewis. Details are the currency.
Exactly. And stick around because in Scene 6 we are going to cover the specific mistakes that get letters thrown out.
Now here is where a lot of veterans get confused, and I want to make sure we are clear. Your personal statement is not the same document as a buddy letter. A buddy letter is someone else describing what they observed about you. A personal statement is you describing what you experience every single day.
The form is VA Form 20, 1-40, 138, Statement in Support of Claim. This is your chance to tell the VA what the medical records do not capture.
The reason this form carries weight is rooted in the same lay evidence framework. Under 38 U.S.C. Section 1154, the VA must give due consideration to the places, types, and circumstances of your service.
Here is how I think about the difference, Bella. The buddy letter is a witness on the stand. The personal statement is you on the stand. Different testimony, different perspective, both admissible.
In your personal statement, describe your worst days. How does the condition limit your work? Can you drive, cook, exercise, play with your kids? The VA rater needs to understand functional impact.
And please do not downplay it. Veterans are trained to push through pain and minimize problems. That instinct works in the military, but it works against you in a VA claim. If you cannot bend down to tie your shoes without pain, write that. If you avoid crowded places because of anxiety, write that. Be honest about how bad it actually is.
This is the scene I mentioned in the opening, and the historical context matters. For decades, PTSD claims required corroborating evidence that the traumatic event actually happened. For combat veterans, that often meant finding unit records proving you were where you said you were. Congress gradually expanded what counts as proof.
Under 38 CFR, Section 3.304F, if you are a combat veteran, your lay testimony alone can establish the in-service stressor. You do not need buddy letters or service records to prove the event happened.
That is a massive shift. For non-combat PTSD, the rules are different but still more veteran-friendly than most people realize. If your stressor is related to fear of hostile military or terrorist activity, your lay testimony alone can also establish the event.
And for military sexual trauma, the VA recognizes that these events are rarely documented in service records. Alternative evidence like changes in behavior, requests for transfer, and drops in performance can all corroborate your account.
The form for all of this is VA Form 20, 1-0781. As of June 2024, the VA consolidated the old personal assault form into this single form.
When you fill out the stressor statement, be as specific as the memory allows. Where were you stationed? What was the approximate date? What unit were you with? And what happened?
Think of Lewis's point like this. You are giving the VA a map with coordinates. The more coordinates you provide, the easier it is for them to find what they are looking for. Even one landmark helps. Remember the sticky note analogy from Scene 1. Let me show you the 5 mistakes that turn a strong buddy letter into a sticky note.
Mistake number 1. Writing opinions instead of observations. He deserves 100% is an opinion. I watched him struggle to get out of a chair every morning for the past 3 years is an observation.
Mistake number 2 has a long history of killing otherwise strong claims. Being too vague on dates and details. sometime in 2015 is weak. During our deployment to Bagram from March to September 2015 gives the VA something they can actually verify.
Mistake number 3, not describing the impact on daily life. The VA rater needs to understand how the condition affects the veteran right now. Can they work a full day? Can they stand in line at a grocery store? Those are the details that connect the condition to a rating.
Mistake 4. Submitting the letter without the correct form. Using VA. Form 20, 1-10210 for buddy letters and Form 20, 1-40, 130, 8 for personal statements gets your evidence routed correctly.
And mistake 5. Not confirming the VA received the evidence. Mail your forms to the VA Evidence Intake Center in Janesville, Wisconsin, or upload through va.gov. Then check your claims file to verify it appears in the record.
If you forget everything else from today, remember this: specific, observable, dated, and on the right form. Those 4 words are the difference between evidence that changes a decision and paper that gets ignored.
Drop in the comments whether you have submitted a buddy letter or personal statement, and what advice you would give to someone writing their first one.
Okay, it is quiz time. Let's find out what stuck. Think through each question carefully before you answer.
Drop a like if we earned it, and subscribe so you never miss the next episode.
A veteran asks their former squad leader to write a buddy letter for a knee injury claim. The squad leader writes, he is a good soldier and deserves his benefits. Why is this letter unlikely to help the claim? The correct answer is A. It contains opinions and character references instead of specific, observable details about the injury and its impact on daily life.
A combat veteran is filing a PTSD claim related to a firefight during deployment. Under 38 CFR Section 3.304F, what level of evidence is required to establish that the in-service stressor actually occurred? The correct answer is B. The veteran's lay testimony alone can establish the stressor, as long as it is consistent with the circumstances of their combat service.
A veteran wants to describe how their service-connected back injury affects daily life. Which form should they use for their own personal account of the condition's impact? The correct answer is CVA Form 20, 1-40, 138, Statement in Support of Claim, which is designed for the veteran's own account of their condition and its daily impact.
Michael here. The analogy I keep coming back to is the photograph versus the sketch. The VA needs a clear, detailed photograph of what happened and how it affects the veteran today. Specific dates, specific observations, specific impact on daily life.
Lewis jumping in. From 38 U.S.C. Section 1154 to Jandrau v. Nicholson, the courts have repeatedly affirmed that lay evidence is real evidence. The VA must consider it. The only question is whether you gave them enough detail.
Bella here. The thing I want every veteran to hear is that writing about your condition is not weakness. It is you building the strongest possible case for benefits you earned. Ask your buddies for help, be honest, and do not minimize what you go through.
3 documents, 3 forms. Buddy letters on Form 20, 1-10210. Personal statements on Form 20, 1-40, 138. PTSD stressor statements on Form 21-0781. Next video, we cover claim types and filing strategy. Intent to file, fully developed claims, 1151 claims, and benefits delivery at discharge. Choosing the right claim type at the right time can mean thousands in back pay. That is VA Benefits 1.32. If this series is helping you claim benefits you have earned, subscribe. We are covering every major VA program so nothing gets left on the table. Professor Erica signing off.